Hey everybody. Hello, 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 how. How's everyone doing this evening? Let me go in the chat and say hello to y'all folks because Empress is ready here. She's here ready to read, right? Hey Empress. All right, I'm gonna put her down for a minute until she'll be.
I'm here.
No, go ahead on. I gotta say hello to my folks first, and
Okay,
then
perfect.
I'll bring you back up. Okay. All right, guys. Let me say hello to some of you guys in here first. We got answers from the judge. You guys are not going to be happy. You guys are not going to be happy at all. So I'm forewarning y'all. Hey, Cavell. Hey, Raquel. Hey, Charlie. Hey, V. Davis. Hey, Dialogue with Me TV. Hey, Kim Morris. Hey, Tiffany. Hey, Jill. Hey, Natasha. Hey, Gemini 777. Hey, Kim again. Hey, True Story. Hey, Green Eggs, no ham. Hey, Cavell. I said Cavell, right? Hey, Tall Glass. Hey, Lucretia. I know you half of y'all want to yell and punch the wall and all that. Calm down, y'all. Calm down. Hey, JT. Hey, Kiki. Hey, Dream. Hey. Whew, y'all get me tired with all the names. Hey, Blue Skies. Hello. Is it Marley? Hey, let's see, Bless One. Shanta. Hey, McCrazy. Hello. Let's see. Who else? Same people typing up. Same folks. Impress. I know you up here. Hey, Kara. Hey, Jesse from the NAP. The NAP. Hey, let's see who else. Annabelle. Naughty Lynn. Miles over Smiles. Hey, who else? Let's see. Okay, hey everybody. Hey Yota. Hey Goldilocks. Hello Diana. Hey crazy viral crazy me. Hey Mr. 444 Smile. Where am I at? I'm at home. Okay. Well, guys, I just want to tell you I stay late at that court. You know why I stay late at court? Because you guys was in the chat. Miss Sylvia, go get it, Miss Sylvia. Miss Sylvia, go get your order. So I went and got my order so I can get in before 8 o'clock. So, because I know y'all was just like, Miss Sylvia, go get it, Miss Sylvia, go get it, Miss Sylvia. We want you there, Miss Sylvia, go get it. So I got it. Okay. So I got it, okay? Oh, Lord have mercy. I did get it. But let me go ahead and bring my peeps up. All right, here we go. There she is.
Hi.
Hi. All
I'm
right,
ready to
y'all.
go today.
Are you ready to
Yep,
go?
I got my water.
Uh-oh. She got her water, y'all. She got her water. Let me go ahead and go get the stuff. Let me go get the documents.
Okay.
Let me go get the documents so we could be ready for you guys to read. She got a lot to read, so she got to drink a lot of water today.
Woo.
Drink a lot of water. She got one that has like what, 27 pages, right? 20.
Yes, ma'am. Yes, ma'am. I'm ready to go though.
She ready to go, y'all. She fired up and ready to go. Wasn't that terminology during Obama's campaign? Fire up, ready to go. Fire up, ready to go. Okay, hold on. It's that one. Got that one. Got that one. And all right, let's get to the first one. The first one had to do with Kayla.
Okay.
All right. It's called, hold on, let me pull it up for you guys. You pull it up. All right, we're gonna start reading this one here. Let me pull up my stuff here.
Okay.
Hold on. Let me get myself together now. Hold on. All right, here we go. You guys ready? You guys see it? Let's go. Let's get ready to rumble. All right.
Okay. So the state of Georgia versus Jeffrey Williams, the defendant. Order regarding alleged ex parte Brady violation. Defendant Williams made an oral. I'm sorry. Let me start over. Hold on. In fact, got to cut off my notifications. Let me do that. Okay. Order regarding alleged ex parte Brady violation. Defendant Williams made an oral assertion on August 2nd, 2024, that during a June 10th, 2024, in Chambers ex parte meeting, there was an off the record discussion amongst witness Kenneth Copeland, his attorney Kayla Bumpus, and prosecutor Simone Hilton, in which Mr. Copeland discussed the murder of Donovan Nutt Thomas and made a statement or statements inconsistent with his June 10th, 2015 statements to police, which, if not disclosed, would constitute a Brady violation. The court heard testimony concerning that matter on August 5th, 2024, from Bumpus and from Fulton County District Attorney's Office Investigator Long, who was also present during part of the June 10th, 2024 ex parte meeting. The court finds that an off-the-record conversation did occur at the behest of Hilton and with the consent of Bumpus. Judge Glanville was not present for the conversation. During the conversation, Hilton advised that if Copeland took the stand and either pled the fifth, having been told that such a plea was no longer viable due to the grant of immunity, or claimed that he killed Thomas, as Hilton maintained that the prosecution knew this to be demonstrably untrue, the prosecution would charge him with perjury. Also during this conversation, Copeland made the statement, "You don't know what I did or didn't do." During her testimony, Bumpus claimed that Copeland also said that he knew more about the infinity and someone not currently on trial. But Bumpus also testified that Copeland's comment, quote, "You don't know what I did or didn't do," end quote, was the extent of his comments regarding the killing of Thomas. Bumpus claimed distinct recollections of certain portions of the June 10, 2024 events and acknowledged lesser recollection of other details. She also acknowledged that there were times during the in-chambers meeting when she met and conversed privately with Copeland. Finally, Bumpus testified that once she, Hilton, and Copeland completed their off-the-record conversation and were rejoined by by the predecessor judge and his court reporter, Bumpus consciously endeavored to ensure that she immediately placed on the record everything about the substance of the off-the-record conversation. Yet Bumpus never had the record reflect that Copeland had allegedly just revealed to Hilton that he had additional knowledge of the infinity and a related connection to someone not currently charged. Long was present in the ex parte meeting from the time Hilton and Copeland joined throughout the remainder of the meeting, including for the off-the-record conversation. Long testified that Copeland never said anything about an infinity in Hilton's presence, and that he would have remembered such a comment because it would have been noteworthy. In addition to the testimony of Bumpus and Long, the court has considered Bumpus's knowledge as an attorney of her duties to her client and to the court, as well as the possibility that Bumpus, who admitted a lesser memory for certain portions of the ex parte meeting than others, may have confused her private conversations with Copeland and her conversations with Copeland that also included Hilton. Regardless, the court credits the testimony of Long that Copeland did not, in the presence of prosecution, either state or intimate that he knew more about the infinity and its connection to someone not currently on trial. So no additional Brady material was revealed in the consensual off-the-record meeting amongst prosecution, Copeland, and Copeland's counsel. As this court finds that as there was no Brady violation with respect to unreported portion of the June 10, 2024 ex parte meeting, there is no relief to be provided. So ordered this 8th day of August, Judge Paige Whitaker.
All right. All right. I need to know what the folks think about that. We're going to stop right there on this part, and I need to know what the folks said about that. So you know what? We're going to allow them to come in one at a time while you and I are up here. We're going to let them come up and see what they have to say about that. So basically, the judge is saying that she do not believe the testimony of Attorney Bumpus. All right, let's see. All right, who wants to come up? I know y'all ready to burn rubber on this YouTube world this morning.
But I was gonna say before they come up, let me get my piece in, Miss Sylvia.
Okay, go ahead.
So, do you think, as I read this, do you think that because her testimony was so much more different than everybody else's, because maybe she was trying to save face, that she fell flat on her face, like she just kind of messed that whole thing up?
I think because she kept saying, "I don't recall," about certain things that was like You should remember that part.
Right. It was only a couple weeks ago.
Mm-hmm. And then remember, she did ask if you felt there was certain things that was going on. Why didn't you come to why didn't you say anything to the judge? Because remember, she was up there
Right.
trying to get the Rule 22. And so she could have said something then.
Facts.
And
Facts.
she did not. Oh, here come Prolific. Oh my God. Hey. Hey. Unmute yourself.
Can you hear me?
Yes.
How y'all doing?
Fine. You got 2 minutes. And I'm not gonna let y'all get past the 2 minutes. Go ahead.
I think we all knew that how that was gonna get ruled as far as bumpers. I mean, I think she was just kind of nervous. Some of the stuff she said was true, but she kind of blew it for him on that part. But I think the judge kind of messed up and gave the state just too much room and kept moving the goalposts. I think it was enough grounds to get a mistrial. She definitely said in the other thing that it was Brady, but I guess because they got to get ex parte and all this stuff early that it was, considered not Brady. But I feel bad for thugging on because I don't think this is a fair trial. That's pretty much all.
Hey, don't you not giving up hope, are you?
I think they're gonna win an appeal, but I got hope in the jury at this point. I mean, but I ain't no stopping the trial. That's clear. The judge is not stopping this trial. That's not gonna happen.
All right. Thank you, sir.
All right, y'all.
You ain't getting no dinner or no lunch from me either.
Yeah, the mistrial, you messed up with that one, Miss Sylvia.
No. I still hope for me. See you later. All right. Tall glass. 2 minutes. What
Good
do you
evening, Miss Sylvia. Chat. How's
Hey,
everybody doing?
good.
Oh, that's good. Um, yeah, I'm kind of disappointed with that ruling that just came out, but my stance had been from the beginning that and me personally, I felt like when Kayla was in there in that meeting and she saw what was going on, I felt like she should have been the first one to speak with regard. As soon as she came out, she should have tried to get that on the record. But her movements were to get fired, to get removed, to get relieved. So I'm so happy Steele did stick up and, put that on out there that there was an ex parte meeting had. But my stance has always been when that meeting was over, Kayla should have got up there and said something. That's just my thoughts. But I am disappointed with today. And also when she acted like she didn't know what an ex parte meeting was. That just blew me. So I knew right then it wasn't going to fare out too well for us.
All right. Thank you, Tall Glass.
Thank you.
Don't sound so sad. Come on now. All right.
All
Thank
right.
you. Bye. Hey, Wazler. What's going on?
Hey, Sylvia and Chad. I just want to say that I feel as if I knew from the beginning when Kayla got on that stand that they were definitely going to not believe her testimony. She was not confident in any of her answers. And like many of the people in the chat are saying, she should have took notes. And it looks kind of impeachable when you can remember for YouTube, but can't remember when you're on the stand. But yeah, that's all I have to say.
Wazza, that was short and sweet. All right, Wazza. Thank you so much for your input. Anybody else have anything to say? Before we get to the next reading, anybody else have anything to say on that one? Why is everybody sounding sad? Don't sound sad to y'all. Okay, y'all cannot pray and worry. Okay, cannot pray and worry.
Cannot be defeated, y'all. We still got the jury to come back. Anything can happen. Anything can happen. Come on, keep the faith.
Keep the faith. Keep hope alive. All right, y'all ready? Somebody said she should have filed a motion. I think Kayla was thrown into the fire. She didn't know what was going on. Okay. Yeah, clearly not experience a loyal. Okay, y'all thing is going so fast. Okay, Maya has something to say. 2 minutes.
Oh, hey guys.
Hey.
I just felt like on a stand, like I understand Kayla was upset, and I think that's why she like got on the stand because it seemed like she was a little upset, at the whole how they portrayed her. Um, because if you notice, like when she was, I don't know if you watched her live, but she was like didn't pass the smell test. Like she was offended. I think because before it seemed like she was like trying to shield Love by saying Love was a good person and she used to work with her, but I think her emotions got the best of her because she was so offended. And when she got on the stand, I just think Love did what she was supposed to do, which was she frazzled, and she couldn't really answer the questions. And I think when the judge asked her, like, so you're telling me you didn't know it was an ex parte meeting, it was kind of a common sense question. So I don't think Kate is a bad attorney. I just think Love outplayed her,
Okay. Thank
on
you
that
so
day.
much. Thank you so much, Maya. Appreciate you. All right, Black Butterfly.
Good evening. I just got a question for you, and I'm not going to hold up for the next reading.
Okay.
I want to ask you. So now that we're here, I always think about, okay, let's think about this. Instead of focus on the problem, let's look at a solution. Is it possible that now Brian can subpoena Deputy Brown? Because although, okay,
Remember,
all
they're done
right,
with
so
this now. They're
can
done
he?
with this ex parte stuff. They're done with that. They're not doing that no more.
But can he subpoena him as a witness?
They're not doing anything with the ex parte now. They're not doing it.
Oh,
Done.
okay.
They have
All
it
right,
here.
that's all I had.
All
Thank
right.
you.
Okay.
Bye bye.
See you later, Black Butterfly. All right, Emmanuel.
Hello.
Hey.
Um, I have a different opinion.
Okay.
Um, I guess when she attempted, or what I saw, as she attempted to try to speak, the judge shut her down. That's it.
All right. Thank you so much for that. I appreciate it, Emmanuel. We're gonna go to the next reading. That's it for now, y'all. All right, Empress. You ready for the next reading?
Okay, which one?
All right, let's see which one we're gonna do. We're going to do how many pages is this one? Okay, let's do the order for defendant Stillwell's renewal motion for a fair and constitutional trial.
Okay, give me 30 seconds.
All right, y'all ready? Ready for the next one, guys.
Okay. Order of Defendant Stillwell's renewal motion for fair and constitutional trial. Defendant Stillwell raises numerous assertions. Oh, I'm so sorry, y'all. I've been saying that all wrong. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts has resulted in a denial of his constitutional rights to due process and a fair trial. The pertinent determination is whether such events, if they occur as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Claim 1, a plague of discovery violations, missing police reports, and Brady violations. See footnote 6. Discovery is being addressed. This court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. As recently as the court proceedings on Friday, August 1st, 2024, the court confirmed the state's understanding that Brady obligations include a disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Claim 2, prosecutorial failure to follow court orders, making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. See footnotes 7, 10, 22, and 23. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendant's right to due process and a fair trial, no specifics established in this assertion and no claim of resulting legal error is alleged. Any potential error stemming from prosecutorial failure to follow court orders may be addressed on motion for new trial and or direct appeal, assuming any conviction. Any specious allegations against defense counsel, counsel for a witness, or lack of candor with the court is, at minimum, extremely unfortunate. These items do not, however, establish a denial of defendant's rights to due process or a fair trial, and the court at present declines to impose the extreme sanction of removal of any offending prosecutors. Claim 3, improper evidentiary rulings by the predecessor judge. See 8 and 9 footnotes. A defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. That was a quote. People versus State, 295, Georgia 44, 55, 757. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation. ID can be can be addressed in post-trial review. That was incorrect. Claim 4, mistreatment of defendants and their counsel by the predecessor judge. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. The alleged mistreatment of defense counsel detailed in Exhibit 9, A, E, and H is not alleged to have occurred in front of the jury and, even accepted at face value, would not rise to the level of a violation of defendant's due process or fair trial rights. As to remedies, the predecessor judge has been recused, and the contempt issue outlined in number 9H is moot. Turning to alleged mistreatment in front of the jury, Exhibit 9, B, and D, a judge has broad latitude in determining how to control the courtroom and directing attorneys to, quote, sit down when overruling objections falls within that latitude. This court will give a remedial instruction directing the jury to disregard any disparaging remarks about counsel. Claim 5, improprieties and illegality of the June 7, 2024 ex parte conference. See footnotes 20 to 27. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court. June 7, 2024 transcript is attached, page 94. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Copeland, as the immunity order had been signed in open court early in the same day's proceedings. Even assuming a right to be present for, Even assuming a right to be present for this June 7, 2024 conference, no one on the defense team objected to the request or sought more information about it, thereby waiving any right to be present for that conference. See Nesby v. State, 310 Georgia, 757, 761, and 853. Also citing Hanifa v. State, for the proposition that defendant waived right to be present by failing to object after being informed the trial judge's meeting with the jury outside presence of the defendant and counsel. As for topic of this ex parte conference, defendant assigns nefarious intent to prosecutors Love and Hilton's representations about their intentions with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to view their representations, but refers the prosecutors to its footnote herein. Defendant complains that the comments by the predecessor judge during this conference reveal his partiality to the state. Pretermitting the questionable accurateness of such characterizations, this issue has been mooted by the recusal of that judge from the case. Claim 6, illegality of the June 10, 2024 ex parte meeting. See footnotes 11 through 19, 20 through 20, 24 through 27. On June 10, 2024, at the behest of Prosecutor Love, the predecessor judge held an on-the-record in-chambers meeting with Love and stand-in counsel for Copeland, Kayla Bumpus. June 7, 2024 transcript of ex parte, page 3 through 22. Following a recess at which time Love departed the meeting, Copeland and Prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? Did defendant have any right to be present? Defendant is correct that this meeting was about more than just the perimeters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting, before the first break, centers on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with logistics of handling Copeland's testimony with stand-in counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core and, as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which defendant had a right to be present. See Snyder v. Com of Massachusetts, 291 U.S. 97, 105, 54. It says, criminal defendant has a right to be present when his presence, quote, has a relation reasonably substantial to the fullness of his opportunity to defend himself against a charge, quote, but not when, quote, his presence would be useless or its benefit but a shadow. United States versus Gagnon 470 U.S. 522, 526, and 105 states the presence of a defendant in a condition of due process to the extent that a fair and just hearing will be thwarted by his absence and to that extent only. Says defendant is correct that there are differences between the meeting in this case and the meeting in King versus State 273, Georgia 258, 539, cited by the state. For instance, the meeting in King was to secure immunity for a key prosecution witness, and the defense was aware that the immunity was occurring. Here, the defense was not given a notice of the meeting, and immunity had already been granted to a key prosecution witness. So the topic was not whether immunity was in the public interest. Instead, its topics were the adequacy of the witness's legal representation and logistics of outstanding representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant, what would and would not amount to contempt of the order granting immunity, and compelling his testimony, and the potential consequences of, Los Angeles. What would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. But the state's reliance on King did not demand that its facts be on all fours. The legal import of King for this claim is that because the defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant, a defendant has no right to be present for discussions with the tribunal surrounding witness immunity. The fact that here discussions included what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. See also State versus Lowry 308, Can 1183, 1212 through 1214. No right to be present at hearing to compel witness testimony pursuant to immunity grant. Chestnut versus New York says ex parte meeting at trials court behest between court, prosecutor, and the counsel for witness, initiated after the defendant and his attorney had left the courtroom during a recess at the close of the witness's direct examination, and held to ensure witnesses understood his deal with the prosecution and that he was not unknowingly incriminating himself, and understood his constitutional rights held to be an ancillary proceeding dealing only with the rights of the witness, at which defendant has no right to be present. Was the witness testimony coerced? Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has the right to trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations relating to what crimes or crime the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Webb versus Texas 409 U.S. 95, 95 through 96, 93. It's the touchstone for evaluating claims of coercion by trial court of a witness testimony. Archer versus State 383 provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness determination whether to testify. Here, Copeland had the benefit of counsel. The predecessor judge did not on the whole use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not induced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to pretermit this issue, acknowledge past inaccuracies, and advise Copeland anew. This is the course that the court has proposed, and the parties have affirmed its emphasis. Was there a Brady violation? This has been a long-running and multifaceted proceeding. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waning, and a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue, and yet, as soon as Copeland joins the June 10, 2024 in-chambers ex parte proceedings, he states, "I have never been truthful a day of my life until I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole, but the fact remains that for a defense attorney, this nugget by a key state's witness is gold. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material. The defense now knows of the statement and indeed of all what occurred during the June 10, 2024 ex parte meeting. The contents of this meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce suppression of this information does not technically amount to a Brady violation. But the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration. What it does provide is cause for sober reflection and examination of processes, procedures, and approaches that permitted this likely inadvertently but nonetheless serious Brady lapse to occur. The defendant seeks as a sanction disqualification of the state's 2 lead prosecutors. Because this does not appear to the court to have been purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statements, the court does not order disqualification. At this time, the court is cognizant the defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake. That the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders this remedial measure that the entire prosecution team working this trial submit to training. I'm sorry. I'm so sorry. The court therefore orders as a remedial measure that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. This training will consist of a video replay of training on this topic previously presented by the Prosecuting Attorneys Council of Georgia. The court will provide the video and the viewing will occur under the direction of the court. So ordered this 8th day of August, 2024. Oh my God. Oh. I thought I was going crazy. Can I not hear Miss Sylvia? I was trying to hear her. She was talking, but I couldn't even hear her. Can y'all hear her? I thought I was going crazy.
No, I'm sorry, Marva, because Marva's thing has.
Can you hear me?
Yeah, I can hear you. Go ahead, Marva.
Okay. I'm sorry. I came in late.
Why you calling me? Don't call me. I got it. Oh my Lord.
Okay, so
Marva, you gotta mute your thing in the background. You gotta mute your.
Okay, that's so. Okay. Okay, so I came in late, and I only heard the end.
You gotta mute your thing in the background.
I thought that I did. You mean my fan? Maybe it's the fan.
No, I think it's your TV or something that's playing me.
Okay, yeah, let me see if it's totally down, because I look at the TV.
Okay, because I hear.
Can you hear me clearly now?
I got you.
Okay, so I came in late, and I apologize. I only came in at the end of the first reading about Kayla, and Sylvia, you were saying that the judge did not. Basically, the synopsis was that the judge did not believe Kayla. So I had followed Kayla a lot on YouTube, and I thought she just did too much. She was really involved in the case for a few hours, and the way she ran around YouTube, it was just excessive. But in her defense right now, one of those videos that she had with Kenneth Copeland, she asked Kenneth, and that was one of the other things. I thought she was putting both Kenneth and herself at risk by talking about the case so much on YouTube while he was still a sworn witness. So in one of those videos, she asked him, "Do you think the transcript was complete?" And he shakes his head and says no. And she kind of responds, but then after he goes off, she makes it very clear to the audience that the transcript was complete, and that the minus the off record things that were said. And that's exactly what she said to the judge in the final analysis. It was just that she was very inartful, like Melissa described about her. I feel very bad for her right now because she's being dogged all over YouTube, but the fact of the matter is she was telling the truth in that. So I don't know what that had to do with the with the what the judge came down with, because I didn't hear that part.
Yeah,
That's it.
she basically said certain parts that she couldn't recall, and
Mm-hmm.
and you remember when the judge was talking about asking her why didn't she come to her in the beginning and say something about the meeting and how she
Mm-hmm.
felt it was inappropriate, because she said, she's been there a certain amount of time and she should have came to her.
Well, I agree with Tall Glass when she said that Kayla should have came immediately. She should have been the first one. She should have been on the phone with Melnick, and she should have even intervened more in that meeting in terms of letting him know that immunity deal was not all that great, and really advocating more for him. But I think that Kayla's problem was that you can't be friends with everybody. She was friends with the with the prosecution. She worked with them. She knew them. She kept referring to them by first name. Then she's hugging Thug, and she knows them, and she's on there on YouTube with Thug's sister. So she put herself in a mix of everything that really got her to this position, and we all need to be sympathetic with her and give her grace. That's all I'd like to say.
Okay, thank you, Marva.
Hmm.
All right. Anybody else would like to come up and say something? FBF Production, you said you have something to tell me. Did you want to come up, or did you want to call me, or what did how you want to email me or what?
Miss Sylvia, can I respond? Because I didn't get a chance to respond
Sure,
to that
sure,
message. I
sure.
mean, to that motion that took my breath in the middle of reading it. She said that the defense didn't respond in enough time. When they did, Judge Glanville told them that he never responded to the motions about the ex parte meetings. So for her to say that they didn't respond in enough time, that sounds crazy to me. Like, they responded almost immediately. How much sooner should they have said something?
I don't know. I don't know. I don't know. Look, I don't know. I don't know. Mm. Okay, you ready to read the next one? Because there's nobody in the back. Let's go ahead on to the next one.
Okay. Yes, ma'am. Which one would that be?
Let's go to that. This one here is two pages. Let's do the where she didn't granted in
Williams.
part, granted in part and denying in part.
Okay, 1 second. Because there's two.
Oh, okay, hold on. Because that one is both of them is the same. Hold on.
Okay, I got the one that you were talking about.
The granted in part. And,
Yes, ma'am.
okay. Hold on. Let me pull this up.
Yes, ma'am.
All right, here we go.
Okay. Order granting in part and denying in part Defendant Williams' motion in limine number 54. Defendant Williams' motion in limine number 54, having come before the court and the court having reviewed the submission and argument from Mr. Williams via counsel, as well as having heard from the state, hereby grants in part and denies in part the motion. With respect to the additional charts concerning cellular telephone data of a new person unknown to Mr. Williams, the state has represented that they will not be seeking to introduce or use these charts. Therefore, while it's essentially moot, the court grants Defendant Williams' motion. With respect to report and analysis by Agent Bernie related to the April 26, 2015 incident, while this was a late and untimely disclosure by the state, I'm so sorry. I'm in Los Angeles. With respect to the report and analysis by Agent Bernie related to the April 26, 2015 incident, while this was a late and untimely disclosure by the state, the court finds that as there is still sufficient time prior to the possible introduction of this evidence, there is not the requisite. Oh my God, I'm sorry. Requisite prejudice to the defendants, nor is there bad faith on the part of the state, both of which must be shown to authorize the exclusion of this evidence pursuant to OCGA 17-16-6, and therefore the court denies defendant Williams' motion with respect to that report and analysis. So ordered this 8th day, August 8th, 2024.
So part of it is approved and part of it's denied. Okay. All right. Now, last one, our final one is the denying defendant William amended additional motion to disqualify lawyer Love and Hilton.
Yes, ma'am. Let me know when you're ready.
I'm ready.
Okay. Order denying defendant Williams amended additional motion to disqualify lawyers Love and Hilton. Defendant Williams asserts that prosecuting attorneys Love and Hilton must be disqualified from the case because of alleged ethical violations during the course of the trial in this case. As noted in the court's August 1st, 2024 order, a defendant seeking disqualification of prosecutors in a trial bears the heavy burden of proving that such an extreme action is warranted. See Lewis v. State 312, Georgia Appellate Court 275 and 283. It is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted. The defendant has submitted 8 examples of alleged misconduct and or ethical violations, which have occurred in approximately 8 months that the trial, since opening statements, has been going. Certain of these items are also enumerated in defendant Stillwell's renewed motion for a fair and constitutional trial. To the extent that they are addressed and ruled upon there, such rulings control. The court reminds all counsel that every Georgia attorney is bound by our rules of one moment, y'all. I'm sorry. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty to a candor of the court. These ethical and professional obligations should be scrupulously honored, and prosecutors, above all, should endeavor to comport themselves as to be above reproach on such matters. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occurred during an impact on case before this court. The court declines that invitation at present. The court certainly does not condone the alleged actions of prosecutors Love and Hilton. The court has, in the weeks since assuming presiding duties, made clear the expectations of all counsel, and the court admonishes counsel that any future failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction of removal from this case. Upon consideration of defendant's motion and of applicable law, defendant's additional amended motion to disqualify prosecutors Love and Hilton in this trial is denied. So ordered this 8th day of August, 2024.
So she basically tell him,
wow,
do it again, you're gonna be out. She's saying that, you know that,
it's
right?
It's in writing now. It's in writing.
She said, you do it again, you out. And she said that basically they weren't being candored.
Which is crazy.
Yeah.
All right, I'm down.
All right, so we got this. We got this now. So guys, she flew out of here, y'all. She flew. She's trying to get her food down. She's trying to get, thank you, Impress. Impress said, I'm out. I'm out. I wanted to play what we talked about earlier this afternoon in regarding to what the judge said about the jury coming back. I'm going to go ahead and play this for you. Oh, everybody's up right now. Everybody's up reading these motion. I see. All right, let me go ahead on and play this part for you guys. From this morning. This is like right before our little break. Trying to put that up for you. Hold on a second. Let me just put this on. Hold on.
Anybody who's an attorney would consider disparaging, unprepared and unprofessional. So I'm going to address that and seek to cure that by just using that actual word. So that has changed with regard to my just general opening instructions about being the new judge on the case. Now we have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he decides at this point, you know, on Monday not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right. All right. So Mr. Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion. And that being, I think like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder, disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony that and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that so I at this time, I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so I mean, y'all have had the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah. I mean, I'm not saying I haven't looked at it. I'm looking for and reading.
Yeah. So, I mean, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that?
So
you do? Okay. What's the answer?
I misspoke yesterday. but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors. They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes. And I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So he was getting there.
Okay, but if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background.
It's a little
So,
bit relevant.
so what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So, Judge, it's when you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean, and we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
I think it's safe to say that that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion.
All right. Is there anybody that disagrees with that? All right. Thank you.
Specifics of the night.
I'm gonna go fast forward a little bit, guys. I'm gonna move it up a little bit to the part that
Exhibit 378Y, as in Yankee, B as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's a January 28th, 2015 interview.
Okay.
And then I have I have the January 11, 2015 interview marked at States Exhibit 358A as an Elisa, and it's at the time I just said, which is 329:46 to 330:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 329:46 to,
330:13.
okay, thank you.
And that's at 358A as an Elisa.
All right, and I think that's our review had only revealed those two, anything from those two videos also.
I'm trying to find out the spot.
All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know. All right. Silence. All right, turning back to Mr. Steele's proposed instruction. You're saying that as to collecting their notes, they're going to be sealed for the record. Why not just destroyed? And I don't even know if your mic's working right now. We might need some more batteries, but.
I was given more batteries, but this should be working, I hope, anyway. I just, from doing death penalty cases, that we don't destroy anything, but we don't get to look at it. The court can look at the notes, I guess, but it goes under seal. That's how I've always been taught.
I mean, why would there be any relevance whatsoever, even on appeal, to what jurors might have written down about something we then take from them and tell them to disregard?
I understand. This is just how
Okay. I mean, if it were a death penalty case, I would do it that way, but.
I'd have to look at the law, though. But
okay, well.
But I can't answer your question other than, yes, I understand at the end of the case.
All right.
No
frankly, I don't need to tell them what I'm doing with them anyway. So if I do seal them for the record, I'm not going to tell them that. If I'm going to destroy them, I might tell them that. But so if you want to give me a law on that, great. All right, now, one other thing that I propose to do, because we're telling them there's this chunk of testimony from a couple of.
This is the part, y'all. Listen carefully. We're going to probably replay this one again from 5:30:40. 5:30:40. All right. You know me. I like to replay the interesting part.
Days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do, in addition to instructing them on that, is to then do some version of, and Ms. Persfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial, but.
Did y'all hear her? Did you hear that, guys? Y'all heard that? She said, basically, she's going to poll the jurors. After she gives the instruction, she's going to poll the jurors of those who don't feel that they can basically abide by, forget about what they said, what was said in the testimony. Can they forget it? If there's enough jurors that say they can't, it's going to be a mistrial. Let you know if you got the PayPal. I don't have the phone in front of me. As soon as I go downstairs to get the phone, I'm gonna go ahead and play this, and I'll go get that phone, and I'll go check it out. Okay, Hipsy, thank you. Okay, I'm gonna replay it again for you, Texas Black Diamond. I'm gonna play it right here. This is what she says. Okay, here we go.
Chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do in addition to instructing them on that is to then do some version of, and Ms. Persfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial, but better to go ahead.
We need to find out how many jurors has to be on a criminal trial. Does it have to be 12, or can be less? Can it be 9? Because she's saying 8 jurors, but according to the numbers that we know, it's less than 8. It should be 5. It should be 5 because they only got 4 alternates because 2 of the alternates are gone. It has to be 12 jurors for a criminal trial. 12 jurors, okay, because I know it's 6 jurors for civil, but it has to be 12. Okay. Okay. So it's 5 then. If 5 says no, because she said 8. Yeah, it is a total of 16 right now, right? But 4 are alternates. There was 6, but they're gone. They got 4 alternates. 2 of them left. She has not addressed Weinstein. It has to be 12 for alternate to be okay. So it's 16 together altogether. So she doesn't know somebody already dropped. She probably doesn't. She probably don't. She really needs 5. She needs 5. Because if she has only 4, it's still 12 jurors. 8 people to say no that won't have 12. She only really need 5. You won't have 12 if you have 5. Because yeah, so it shouldn't take but 5. Exactly, Terry. In her head, she keeps saying 8. I don't know why she said 8. Because even if you had the extra 2, that's 7. That's not 8. So I don't know why she said that. Only 5. Maybe she just giving an example. Hold on.
And figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Persfield, do you have the site for it? It looked like a pretty good idea to me.
You heard her? You said it looks like
Davis, Davis v. State.
It's Davis v. State. Davis v. State. And that's a Georgia case, right? Let's go see what it says. It's the Supreme Court 1960. Hold on. Okay, here's one. There's a Georgia v. State 2024. That's he was okay, here we go. All right, I'm gonna read it to you guys. Following a trial of a jury convicting Richard Davis on 4 counts of child M and 1 count each of aggravated SB, attempted SA. Oh my God, it's got a lot of that's terrible stuff. I don't want to say all these words on this thing here, but bad stuff to children. Okay, I'm not going to read it. Now, Davis' appeal argued that the trial court erred in denying his claim that his trial counsel rendered ineffective assistance when he failed to object to numerous notes going out to the jurors in alleged violation of continuing witness rule. For the following reason, we affirm his conviction and the denial of his motion for a new trial. Okay. All right. It says, view in light of the favorable to the juror's verdict. The record shows that in 2010, David began living with an adult daughter, blah, blah, blah. We don't want to hear about that nasty stuff. Hold on. I want to see what it says over here. He says the error did not err. Maybe it's a different case. This must be a different case, y'all. It's a different case. Let me go find. Let me finish listening to what she says about the case, because that's a different one. This one has to do S word.
And that is it. 307 Georgia.
Hold on. 307 Georgia. 746. 746.
Don't have a pinpoint, but I believe it's towards the yeah, it's towards the end. It's either the last or the second to last topic that the appellate court addresses. And it even includes the instruction, and I may look at that and maybe borrow some from that as well. So y'all can take a look at it too.
What did she say again? Let me repeat that one. Let's see if we can find it. Hold on.
Law on that. Great. All right. Now, one other thing that I propose to do, because we're telling them
hold on, I just got
this is a chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do in addition to instructing them on that is to then do some version of, and Ms. Pursfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial, but better to go ahead and figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Pursfield, do you have the site for it? It looked like a pretty good idea to me. Judge, that is Davis, Davis v. State, and that is at 307 Georgia, 746. Don't have a pinpoint, but I believe it's towards the yeah, it's towards the end. It's either the last or the second to last topic that the appellate court addresses. And it even includes the instruction, and I may look at that and maybe borrow some from that as well. So y'all can take a look at it too.
All right, hold on. Let's see. Let me go see if I can find it. Hold on, y'all. Hold on. Okay. All right, this is it. I found it. I found it. I found it. It says here that holding that improperly admitted testimony suggests that the defendant was the shooter was harmless because the state presented strong independent evidence of the defendant's guilt as a party to the crime, and the jury was charged on parties to a crime. And it says Davis versus State, and gives you the appellate people name. Okay, let's go down. Let's go down. And where the kid, David's appeal, arguing that the trial judge abuses discretion in admitting certain testimony by a Georgia GBI agent in denying his motion for mistrial, and that to the extent that this court concludes with that he waived certain evidentiary objection by failing to raise them at trial, his trial counsel rendered ineffective assistant of counsel. We affirm. Okay, we view the light favorable to the verdicts. The evidence presented at trial shows as follows. Davis lived with an older brother, Jonathan Wright, and their grandmother in the house. Okay, blah, 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 blah. The next morning, David, I want to hear what the appellate court says about the thing. All right, we don't want to hear all that. We don't want to see all that. Okay, let's go. David took place in December 2012. All evidence code is in effect. Okay. Defendant's guilt. Okay. Based on foregoing. To reverse David's conviction, however, the error must have harmful. As David conceded in his opening argument statement that his sample was ample evidence in the blah, 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 blah. I want to hear the part about the jury. That's what I'm looking for. Okay, they're talking about the case. I'm going. Okay, we got to go to the jury part. Okay, it says, after the jury returned to the courtroom, the trial court instructed the jury as follows. Ladies and gentlemen of the jury, when I asked y'all to step out of the courtroom, just before that, the state had asked Lynn a question. Lynn was beginning to respond to the question, and the defense objected. While y'all were out, I ruled that objection is sustained, and therefore you should neither consider the question that was asked nor this witness response to the question that was responded. To add that last question and answer right before y'all went out the courtroom, okay? Because I have sustained the objection, it is most important that you not consider the question nor the answer in your deliberation during the trial of this case. Now, is there any of the juror who cannot set? Oh, there it is right here. There it is right here. Oh, there it is. There it is right here. Now, is there any jurors who cannot set aside and totally disregard the question and response to that question as part of your deliberation? If you cannot set that aside and completely disregard it in your deliberation, I want you to please stand up right now, any of you. And then he says, okay, none have stood up. That being the case, the trial will proceed. Okay. So we reviewed the trial court denial of motion for mistrial for an abuse of discretion, and then they give a case law. We will not disrupt a trial court's ruling on a motion for a mistrial unless it is essential to the preservation of the right to a fair trial. Here, the trial court ensured that Davis retained his right to a fair trial by giving an emphatic recodific instruction and polling the juror as to whether they were able to disregard Agent Lynn improper testimony. None of the jurors indicated that they were unable to disregard the state's question and Lynn's answer. Accordingly, the trial court did not abuse its discretion with respect. It says, no abuse of discretion in denial of mistrial where the trial court instructed jurors to disregard improper testimony, witness testimony. Qualified jurors under oath are presumed to follow instruction of the trial court. Citation and punctuation omitted. And finally, okay, so that's what she's going to do, y'all. She's going to poll the juror and whether or not they can bypass all that. And if they say yes and no, the amount of jurors that says no will be declared a mistrial. So why did y'all say 8 to, that's when they voting. That's when they're voting. If I'm hearing right, because the juror's case was dismissed. Them jurors will say yes. Watch. You think they're gonna say yes? They can forget what he polled. You think they're gonna say yes? 12 jurors to deliberate. Period. 8 in the majority rule out of no. How long did this case last? Really 4 because it takes 8, right? 8 to deliberate. So 8 out of 12 with the 12. I think Gemini, you're talking about something totally different. You're talking about as far as them deliberating. This is her polling them, and she's gonna poll. Well, is she gonna poll? Wait, hold on. Is she just gonna poll the ones that are real jurors? If she's polling the one that's all real jurors, so she's gonna poll and see if 8 is left over? Huh? It's not 18, it's 16 right now. It's 16. She probably don't even know how many jurors we have left. She probably don't even know how many jurors. That's probably why she's just saying 8. She probably don't even realize how many jurors we got left. We'll just wait till she come in and talk about. She probably don't even realize we got 16 instead of 12. Hey, let me tell you something, Robert. If these jurors wants to get off this case, they're gonna say, they're gonna be polled, and they're gonna get their butt off. I'm telling you, you think that no, this is the opportunity to run to the hills. And I guarantee you they're going to run to the hills. This is the opportunity. They're watching right now and they say, hey, what is my opportunity to get off this trial? This is my opportunity. Let me just run to the hills. I watch, y'all, watch. They're watching all these things. They've been trying to figure out how to get off this trial. Y'all, I'm telling you, you know how many times they've been asking for days off? They want to do this, want to do that. They don't want to be here. I told you. I watched them. I'm telling you guys. I'm telling you from my observation and what I've seen them. Okay, they've been looking for opportunity. Because remember, one of them was trying to say, "Hey, I live right down the block from where it's happening," and the judge's like, "Nope, you stay in." They've been trying to figure out a way to get out of this. They wanted days off. They want one has to go medical. The other one has this. They've been trying to get off for the longest. Now, this is an opportunity to run to the hills, and they're going to run to. I'm not trying to be funny, but I'm just telling y'all. They're going to run. Robert tried to tell you, no, I'm telling you, this is an opportunity for them. They're going to. All right, let me put in the link in here. Can I describe their appearance? I'm telling you, y'all, they have an opportunity to get out of Dodge. $25 a day. I'm telling you. They've been praying to God for an opportunity. They're like, Lord, help me, give me an opportunity. Help me get out of this. And God opened up us like, oh. Oh, God. Oh. No, this is an opportunity. I hear you, Miss Sylvia. No free lunch or anything. I get it. Look, they've been off a whole month and they feel the freedom of being home. They feel, come on, y'all. I'm telling you. I'm telling you, some of them been praying, Lord, give me a way of escape. And look, the Lord opened up the windows and they say, Mom, I'm gone. They said, I'm gone. I got an opportunity to get the heck out of here. You know, come on now. Y'all been around. Y'all heard them asking for time off because they wanted time off in July. And guess what? They got the whole month. They ain't even have to use no time. You want their name, Britt? Britt, you funny. You ready? You ready for the name? Ready? I gotta go from the front. You got Ryder, you got Goober, you got Trini, you got Nose, you got Mouth. No, hold on. I'm going from the front. You got Ryder, you got Goober, you got Trini, you got Ghost, you got, oh, that was Ghost. You got Twister, you got Zesty, you got SpongeBob, you got Zesty, SpongeBob, you got Nose, you got Mask. I can't remember the other one. Did I say Zesty? Yeah, I did say Zesty. I did say SpongeBob. Fluffy. Got Fluffy. Okay, so I'm telling you, Twister's gonna get out. I'm gonna tell you that. Zesty gonna go get out. Trini is out. Goober is out. Okay, Mask might say that she might forget it. Mass might say she might forget it. Okay, y'all. Mass is the one that I saw. Don't tell. But anyway, SpongeBob. Yeah, SpongeBob will be gone. Zesty Twister. Okay, I'm gonna tell you the other one. Now, Ryder's gonna stay. Ryder's gonna stay. Mask is gonna stay. Let's see. But I'm telling you, Twister's gone, Zesty's gone, Trini is gone, Goober is gone, SpongeBob is gone, and Fluffy's gone. They're gone. Fluffy's gone. Fluffy always wanted something to eat. Fluffy's gone. Empress. Hey, Empress.
I have a question because there's quite a few of us that have the similar comment, a question rather.
Okay.
So, are they asking the jury, is this before or after they ask Woody if he's testifying or not? Does this come into play if he testifies or if he doesn't testify? Or how is this jury?
They're going to ask him first.
They're going to ask Woody first. So this only comes into play if Woody says he's going to testify, correct?
Once to Woody get ready, they say yes to Woody, they're going to pull the jurors in, then they're going to poll the juror. And when they poll the jury, they're going to ask the jury whether or not they could forget about the testimony that, they heard previously from.
Thank you for clarifying that. A lot of us were going back and forth, so I just wanted you to clarify that for us.
No, Woody's coming first. Woody's coming in first.
Okay.
Because the jury don't come in until 9:00. Woody comes in at 8:45, but we come in at 8:00. So, but I'm telling you, Swifter is no. Zesty is no. Trini is no. Goober is no. Fluffy is no. SpongeBob is no. Those I know for a fact. Okay? Now, nose. I don't know about nose. Will that be enough? I don't know. Oh, you want the link to speak, and Sandy? Okay, hold on. Sandy want to speak. Twister is going to say she can't forget. Twister was out. Twister's been praying to God, say, Lord, help me. Let me get out. Let me get out. Oh, God, they want to get out. They want to get out. They want to get out. They probably going to pull them in there one at a time. One at a time. They usually pull them in one at a time. Yeah, they're going to pull them in there one at a time so they won't know what the other ones are saying. Which one was that? I just told you. I'm not going to tell you again, Jackie. You missed it. I just told you. I just told you. Bless. Look, don't be trying to put it out there, Bless. Bless. Delete the answer, y'all. Delete the answer. Delete the answer. Hey, Doc.
Hey, can you hear me?
I can hear you, Doc.
Let me tell you something. Girl, I'm telling you, those jurors, and I put it in your chat that if they are government workers, they're going to agree that they can they can forget because they're getting paid. They will get paid to eternity. Trust me, I know. So if they are self-employed or they're
How
not
about if they just don't want to be there no more, like the
no
way
no 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 no
I'm
no
telling you, Twister don't
no
believe
no
it.
Sylvia, no Sylvia. If you are a government worker and you're
Twister,
getting your
we
let me
don't talk about
finish.
it's not
Let me
government.
finish.
No, it don't even matter. I'm talking about the
No,
people.
let me finish. As a government worker,
We
you get 100% of your salary. That means you don't even get a performance evaluation after 12 months. So why and then the judge will give them their time off that they want. Why wouldn't they? Come on now. Think about it. You
look,
getting your salary no matter what.
Doc, we're not talking about government workers. I'm talking about people who are
Well,
disinterested.
if they don't, if those jurors are government workers,
All
they
the
will
jurors are not
not they will
government
not fight
workers.
it. They will
All,
not fight it.
all the jurors are not government workers, ma'am. Not all the jurors.
Well,
No,
if they I'm just saying if they are.
they're not.
Well,
Only
if they're not, then they gonna count them out. But if they are, they're gonna be like, oh no, I can exclude that. I can forget it. I can forget it. I'm trying to tell you. Because if I wasn't a government worker, I would not be on that I would not be in that jury box right now because you can find things to exclude yourself at this point. That's the point I'm making. And
well, there
nobody,
was one that was trying to exclude herself, and the judge said, "No, it's okay."
well, she gonna be the one to say, no, I can't forget.
She tried to get because she said she lived in the neighborhood. She wanted to get off, but she
Well,
couldn't.
she will be the one to say, I can't forget.
All right, let me go
Well,
ahead and go next person. Thank
okay.
you.
All right.
All right.
Bye. Bye-bye.
All right. Who is this? Let me take my thing off. Who is this? Who's this person with the John? Okay. Hey, Sandy.
How you doing, Miss Sylvia? Can you hear me good?
I can hear you good.
So I just want to let you know. So you know them jurors, they're gonna ask questions when they come back, and she has to answer those questions in open court. Because you know some of them are gonna be confused. And then I think Miss Ryder, she's like the captain. I don't know. She might convince maybe three or four jurors to be on her side or something like that. I don't know, but
The writer was an alternate.
alternate. Okay, so my mistake. And there is, from where Glanville said earlier, there is an educator in there, because I think the educator was worried about her job. I don't know if I remember correctly.
And she was losing her job. She lost her job, in fact.
Yes,
The school was closing and she had to go do a job interview for her job. It's a new job that she got.
facts.
And she wasn't getting paid like everybody else because she was a private school.
Yes, I remember that.
Mhm.
So I don't think this. I think this judge is already getting overwhelmed. Yes, she knows the law, but she's like picking and choosing, and just like little baby slaps on love is just like little pat on the back, and that's just confusing to the defense team. They see that what's going on, but Steele is very being very calm and collective, and he's gathering more stuff. She doesn't like Harvey. We know that. So that's just my opinion.
I wonder have Harvey ever gone against her in a case and he won, and so she probably still have that remnants of losing to him.
I just think she doesn't like the way he puts himself out there, because she even stopped him today. No, Mr. Harvey, you're not gonna. She kind of stopped him because he was putting his focus on love, and she didn't. I don't know. She was kind of protecting love. So I think she's trying to stop some of that chaos in the courtroom. You know,
Hmm.
but it is what it is.
Mm, okay. Cavell, your thing is showing now you're not connected, so I can't get you up here. But thank you, Sandy, for your input. I
You're
appreciate
welcome,
it.
Sylvia.
All righty, hon.
Thank you.
You're welcome. All right. Anybody else have a thought about it? Y'all, I am just giving you guys my observation from the jurors that I have seen and how they were reacting during the trial. And I remember, guys, I used to give you 411 on those particular jurors. And so from my observation, it's not concrete, from my observation, I can tell you who's most likely going to take that exit, the opportunity of exit. Hey, Cavell.
What up?
What's going on?
Not much. Y'all thought I was tripping yesterday when I was saying about the jury getting polled, huh? Everybody laughed at me.
When the jury gonna be what?
When I mentioned about the jury gonna get polled, when I said they were setting
I'm the
all
one who
the
said it from the beginning.
nah,
Hello. Did I
everybody
not?
laughed. They laughed at me. Said I
But did
sound
I not?
high.
Wait, hold on. Just think back weeks ago when I came into you guys and told you what for the intel information that I had. And I told you that jury was going to get polled, right? But then I talked to some of the defense attorney. They said they don't want to poll the jury. Remember that? I came back and told y'all that. Remember?
Yeah, you was one. You was one of the only one saying it, but you kind of faded away from it because you were letting old boy get in your head with that bet. You was kind of getting discouraged already the other day. Uh-huh. Yeah, you was getting discouraged. And when I had mentioned that yesterday, you started shaking your head at me. No, I said, no, Silver. That jury wasn't up there for no reason. They was trying to fish. But I want to ask you, do they have cameras and stuff in the courtroom, like in the hallway?
Yeah, but you
Like
won't know
like
which one.
like like TV screen monitor showing like what's going on. Do they have those type of things?
On the outside of it, no, they was off. The one at the YSL is off.
Yeah, because I know they have them open dockets where anybody can see what's going on.
Yeah, but they had it off. They had it off. The one right back. It looks like it's broken. In fact,
So if you were the juror, I'm just gonna ask you this and everybody. If you were the jury on this case,
I would have been off a long time ago.
and
I would
it,
find
it
an excuse.
but if you were this juror and you've been gone and you pop up at the courthouse for whatever reason it might be, would you try to be nosy or anything to see what's going on in what courtroom that you was being a juror in? Would you try to check a
No,
document or anything?
I wouldn't because I'd be too scared somebody catch me.
Well, why would you go to that courthouse? Because that can seem like that.
I'd be too scared to. You asked me about me, so I'm going to tell you about me. I would have been too scared to try to check it out because then they'd be like, "Oh, she was up here." I told her not to. So,
So that go back to what I'm saying. That don't sound fishy.
I don't know. But anyway, sir, thank you for your thoughts. I got people waiting.
Uh,
All right, see you. Hey, FB Production, how are you? FBF Production.
Hey, how you doing?
I'm good. How are you?
I'm good. I wanted to come back in because I know earlier I told you I had to tell you something. So once we got done watching the trial earlier, YouTube always going to give you your notifications, stuff you might have missed while you was focused on something else. So what I saw was Lil Woody, of course. We was talking about him today because he's going to have to either testify or not testify on Monday. But he really is like outside chilling. He was walking through the mall like a celebrity, just taking pictures with people, you know, shopping, talking on the phone, no care in the world. So my question to the chat is, do y'all think Little Woody is gonna? I think he's gonna testify Monday because he just seemed like he got like a I can do it kind of spirit right now. He on everything, but he was walking through the mall, just taking pictures with people. Like the street seemed to love him, you know. But it's like it's weird right now. Like he's kind of famous for snitching a little bit. So
No, I think they like him because the way he answered the question on the stand. That's what it is. It has nothing to do with the snitching because on the stand he wasn't snitching.
yeah, but what I'm saying is you're gonna have people that's gonna look at it more than one way. Like we ain't all gonna look at it and say he was on the stand and it was funny what he did or whatever. But like,
But that's
people.
where the fame he's gotten right now is because of the stand and what he
But
was
can you?
saying.
but can you really say all of it comes from just his
Yeah.
actions then? Because now he's out in the public.
Right now, the what's happening right now, the fame that he's gotten is because of his actions on the stand.
So do you think he's going to testify Monday?
I don't know.
See, it's, so I don't know. I feel like it can help him, but I mean, he's doing interviews, he's chilling, like this is over, but it's still a going on, factor. That's all. That's what I was thinking earlier because it, like, literally it popped up as soon as the trial went off today.
All
But
right. Thank you. Got a couple of people waiting.
all right, cool.
All right, hon. Hey, Empress, you're back.
Yeah, sorry. Just I know we went on with the jury and stuff, and I saw someone say in the chat as I was sitting in the back room, they were saying that the jury, I mean, I guess they're contacted daily to make sure that they know where they are at all times and stuff like that. With the way that this trial's been going, you can go into a, bar, you can go anywhere and see this on TV. So are they? Now, I've never done jury duty, so this is why I'm speaking from a place of ignorance. Are they just supposed to literally sit still and like not have a life? Like that's
Yeah.
a real question. I'm like, that's a real question. Like, so for $25 a day, they're supposed to do
Yeah,
nothing.
can't talk to nobody in their family about it, and no, yeah.
So just for this, we're supposed to hold all that in. And then secondly, with Love being at the position that she is with the district attorney's office, with Simone Hilton being the head of the Black Prosecutors Association, the justification that she gave for them getting training, is there something that Steele or any of the defendants can respond to an emotion about that? It's clearly illogical, and these people are, I'm smart, but these people are very, very intelligent people, supposedly. Is there not a way, because that just doesn't make sense, like,
But
you're going to get training.
Once a judge has set an order, that's it. That's it. It's an order.
Wow.
Yeah. And then you can address it in appeals.
Wow. Okay. I just needed that's crazy. Because I'm just looking at it like, okay, so your recommendation is to go to training at their level in their career. They're not novice. These aren't new lawyers that just came out of law school 3-4 years ago. It's not a Kayla Bumpus. No offense to Kayla Bumpus, but these are women that have been doing this 30 years. And the things that they've done that the judge clearly stated that they did, that she saw as an oversight to a case that they've spent however long putting together. And now we've been on the trial for 9 months. That is pure corruption. There's no other way to put like that in itself. But I hope that they went on appeal if it gets to that point, because this wasn't done fairly at all. And I think everybody, I see lawyers, judges from all over talking about it on Twitter. So it's, if everybody else has open eyes to this, why doesn't Fulton County?
Yeah.
All right. Have a good rest of your night.
You too, honey. Nick. Oh, hold on. Nick jumped off. Oh, sorry, like misunderstanding.
Hi, good evening, Miss Sylvia.
Good evening.
So we're talking about the jurors and what they might do. I think that what a lot of people fail to realize that our jurors are just as human as we are, and it's not their profession to have any like legal knowledge. They're just going off of information like everybody else that is observing it.
Mm-hmm.
So it's really unrealistic to think that they are not privy to the things outside of the courtroom that's been going on with this case. So I do believe and Woody is an unforgettable witness. I've been following the trial. Everybody remembers Woody. There's no way that anybody can honestly say they can block out any testimony that Woody has.
I remember his testimony more than anybody else other than Dean.
Exactly. Exactly. That's literally, I mean, he's the most famous person from this trial. And now he's more famous than the defendants at this point. So it's like, well, I mean, with the exception of Young Thug, but I think it's just really unrealistic to people for them to think that they would be able to not consider the things that they already heard and seen prior to this new judge taking over. Oh, by the way, the judge dropped a response to the motion for a fair trial that Shard put in.
You
I don't.
read all of it already.
Okay. All right.
All
Okay. Yeah.
we read. We've been on here for over an hour and a half. We read all 4.
Oh, she dropped 4. Oh yeah, I'm real late. Okay, I gotta catch up. Okay, what do you think about the responses that she?
I mean, it is what it is.
Well, all we can do is pray and hope, and that's
Yeah,
it.
it's. I mean, she gave some decent arguments on it. And she gave case laws on it. So it
Mm,
is what it is.
well, you know she about that case law,
Mhm.
but one thing about the law is that it is meant to be changed. It's meant to evolve. You don't have to always use precedent. You can create precedent. That's how it's supposed to work. So I hate that she's always trying to use previous law as a crutch, because you can set a different standard if she
And
chose to.
usually different standard comes along once the Supreme Court rules on it.
Right, it has to go through a process, but it starts somewhere, right?
Yeah.
So, I mean, you don't just have to. It's not in stone. Like, oh my God, I'm forbidden from doing this. She can still really decide. She has a lot of leeway to do as she sees fit. But we'll just have to wait and see. But my prediction is that Thug is gonna be home before his birthday next week.
Hey, Miss Predictor.
We'll see though. We'll see. I know you're a praying woman, so keep praying, and we're gonna hope for the best.
All right, we got a couple of people waiting back here.
Okay. All right. Thank
All
you,
right,
Miss
hon.
Sylvia.
You're welcome. Bye. All right, Marley. What's going on, girlie?
Hey, I don't know. I'm a little confused today. Um, Irritated today. But I got a question. Okay,
Mhm.
so with the jurors or whatever, and I'm driving, so I don't have my camera on right now.
I
But
understand.
but with the jurors, okay, so if everybody get up, say that they seen it, or they can't, forget the testimony or whatever, it's gonna cause a mistrial, right?
Mhm.
And so they're gonna have to pull another however many jurors in hopes that those new people haven't seen anything, right?
No, they got to start the whole trial over.
Well, I mean, yeah, they're gonna start the whole thing over and they gotta get new jurors, right?
New jurors, new everything. Yeah.
Okay, so would it not be in the best interest of Jeffrey and them to keep the jurors since
They
they
want
over it anyway,
they
and we
want
know that
to
they're gonna get a not guilty?
they want to keep the juror, but I mean, if the judge ruled the way she rules, then
Yeah, but that's what I'm saying. So if everybody go up in there and be like, nah, yeah, I can forget it. I don't remember nothing that man said. I don't remember nothing. I forget it. It's washed. And we continue with the trial. But in the back of their mind, they know they gonna plead not guilty because we don't want to be here anyway.
mm-hmm.
I think I want.
Oops, sorry, Marley. Sorry, I hit the button.
It's cool.
Okay, go ahead.
But yeah, but I think I want that more than the
That's
jurors leaving.
That's what the defense attorney wants. They want to go ahead and go straight through. The only way they want a mistrial if it's with prejudice. That's it. They don't want no other way. So
Oh well.
they want it to go ahead on straight to the jury. Keep
Oh
going.
well,
Keep
jurors. Hey, I don't have anything to do with this. Just my opinion. But if y'all are in here, can y'all just stay so we can get it over with and everybody can go home?
You want them to lie?
Hey, the that's perception, okay? I know not what I hear. I don't know. Hey, whatever.
Somebody,
the judge lying.
Somebody says, Sylvia, don't you think you're telling jurors what to do? How am I telling? First of all, jurors not supposed to be watching. First of all, now let's get with it.
They
Now,
ain't
jurors
even supposed to
are
be in here.
not watching in here, okay? So if a juror is watching this, you are out of order, juror.
You out of line, out there bad. Because at the end of the day, this ain't nothing but free speech and opinions. Thank you, Mr. Just.
You talking about Sylvia? Don't you think you tell the jurors what to do? I'm not telling juror nothing. I'm giving my opinion, and my opinion matters to me.
Yeah, and our opinion, your opinion matter to us, but we ain't nobody.
That's it. That's it.
Anyways, that's all I wanted, jurors. But if y'all in here, you heard me. Bye.
You know what? Marley's so crazy. Lord have mercy. She's too much. Yeah, he's trying to come in here talking about, oh, I think I'm telling the juror what to do. The juror don't need to be in here. If you're in here, then you need to be listening with you're not supposed to be in here. What does anybody remember that in Mr. Weinstein's motion to the Supreme Court responded that if they do not get the relief that they seek from the circuit court, they could come back? Yes.
Hey, Miss Sylvia.
Hey.
It's a quick question. So, now, why you? Oh, Cole told me to tell you, hey, too. But
Hey.
why you couldn't have named the jurors some fruits or something? Apple,
I can't bring
tangerine, banana.
that is interfering with the jurors. I do not talk to the people. Every time I see them, I go the other way. Like when I saw
No,
them.
no, no. I'm talking about with us, cause it crazy. One of them named SpongeBob, so we feel as he laughed too much. The other one named Zesty, so he
No.
like milk and cookies. Like it
You
just
don't
we
know.
just
You don't know what I am talking about when I say those things. I just made up these names. You don't know
was
what SpongeBob look like. You don't know what Zesty look like. You don't know.
well, from my point, Zesty sounds zesty. The kind who like milk and
It
cookies.
could be a girl.
Huh?
Zesty could be a girl.
Hey, she might be a stud. Who knows? Lord
No,
forgive me.
she could be very, very like different.
Okay, but what about SpongeBob? What about Ryder?
What do you think about SpongeBob when you think of some SpongeBob?
Fat, laughing, always giggling.
No, this person don't giggle at all. This person looks so mean.
SpongeBob ain't mean. See, you should name them Mr. You should
No,
name
but
them Squidward.
I named them from what I helped me to remember that person with. So SpongeBob looked really mean.
Okay, so the next trial what we get, can we pick fruits?
Apple and orange? No.
Yeah, Oh, but look though, you need to if you can like once they try, cause I don't feel they gonna last long. It ain't gonna last long. So everybody got their panties in a bunch. Everybody think it down. You gotta believe in God. That's the only way that it's gonna be answered. And the thing is, everybody losing faith. You can't lose faith, cause if you lose faith, then you don't believe God. But look though, you need to get on that 1145, the club 1145. Have you seen that case?
No.
You need to try to get into it.
That's the person got shot up. I don't want to hear that. I don't want to see that one.
No, I'm saying that just give us something to watch. You know, you already down there with your Rue
No,
22.
is Tony streaming that one? Okay, I gotta call Tony because I think he's doing that case.
Yeah, ain't nothing wrong because you got your Rue 22. So
No,
we need.
you gotta do a Rule 22 for every single case that you do down there. You gotta do each one.
Oh, okay. Well, you have a blessed night. I
You too,
appreciate you.
Nick. See you later.
I'm going back to the comment box.
All right. Hey, Q1245.
Hey, Miss Sylvia, how you doing? Can you hear me?
I can hear you.
Okay. I got a question that maybe you can help me understand. So, with the jurors, there's 12. Is there 12 in the box now?
Here's 16.
So that's 16 counting plus plus the reserves.
Four alternate and 12 jurors.
Okay, so that's 16.
Mm-hmm.
So they got to be 12 in a criminal trial, right? So that means that those four. So altogether, only 5 got to be gone and for it to be a mistrial, right?
Mm-hmm. Well,
Oh,
because
that'd
they
be
have to have 12 jurors. I know that to go
so
unanimous.
all we need is 5 people to say that they can't do it. Oh yeah, that's easy. We got this. But yeah, that's
I,
all I needed. That's I was confused and I'm on track now. Thank you. That's all I had.
okay, bye. SpongeBob is bad. That means it is either Squidward or Mr. Crab. You so funny. Y'all, will 7 black women convict Doug? I don't know. Hey, Charles. You said bye. Sylvia, check your email. Oh, come on, y'all. We're not doing the email thing tonight. Why am I checking the email? I'm not reading no more. I'm not reading no more, y'all. We're done for the email stuff tonight. We're done for the email. I'm about to go to bed. All right, guys. I am going to go hit nothing to read. What? You said nothing to read? So what's in the email? What's in the email? Phone number? I'm about to go to bed. I'll check my email later. But anyway, guys, I am about to go to bed. I'm sleepy now. Oh, paper. Hold on. Let me go get my phone. Hold on. Hipster. I don't have my phone with me. Let me go downstairs and go get my phone. Hold on a second. Woo. Okay, I got my phone. My apologies. I got my phone. Let's see. Let's see. You said check my PayPal. I don't see anything in my PayPal. Nope, nothing in my PayPal. Nothing's in my PayPal. Maya, what's the question? Hipster, there's nothing in my PayPal. Can we talk more? It's no court tomorrow. Well, I'm sleepy, blessed one. I'm sleepy. I'm tired. My head, I get up at 5 in the morning and my head is tight. And my head is like, we can talk tomorrow when I get up. But right now I gotta go to bed. My head hurts. Why are we leaving so early? Because I'm tired. You guys don't get up as early as I do, being sitting in the courtroom all day. Your butt hurt, your back hurt, all that kind of stuff. I gotta go to bed. You need a pen. Cash app. Okay, you need to pin. My Cash App is right here on my face. I'm not sick of y'all. I'm not sick of y'all. I'm just gotta go to bed, y'all. I need at least an hour of sleep. I gotta go to bed. Guys, don't y'all think I gotta go to bed? Listen, I gotta go to bed. I'm tired. If it's not, you guys know I sit in that courtroom all day long. Freezing cold. I have to wear winter clothes like this. And I'll be tired. I'm tired right now. I get up at 5 in the morning. I hit that traffic going and coming back. Could y'all have some mercy on me? I'm gonna go to sleep, okay? Y'all don't care. Y'all just want information. And if I don't give it to you, I'll be running off to somebody else anyway. Y'all cheaters anyway. Y'all cheat on me. So y'all got permission to go cheat. Because I'm going to sleep. Y'all cheat on me anyway. So as soon as my stuff not working right, y'all pew. Y'all did that to me early today. Y'all pew the heck with her. Impressed. They cheat on me. Now what was the other question somebody asked me? Oh, Maya said she only comes to my face. Okay, Maya, you didn't cheat. There's others that cheat. They cheat on me because they disappeared earlier. But I'm sleepy for real, y'all. Maybe if I wake up, look at my eyes. See, I can't even keep my eyes open. I'm so sleepy. There was another question I was supposed to be answering. Somebody else asked me a question. Did somebody else ask me a question? You need a booty pillow? Somebody said they was going to give me a booty pillow and they never got me a pillow. I got that stupid leather pillow that I bring out the house and it's hard, but I'm going to go to bed. Go, Mike. See you later. Good night, y'all. Seriously, I'm sleepy. My head's starting to hurt. We need a group text? Oh, no, we don't do group text. You ask my people. I tell them now, don't. Because my phone was constantly pinging and pinging and pinging. I'm not a phone person, y'all. I do not answer my phone. I put my phone down. Most of the time, my phone is on silent. I'm not a phone person. Not a phone person at all. Okay? I'm just going to tell you, I'm not a phone person. All right, I'm going to go to bed. I got to go to sleep. If I get up early, I'll start. I'm sorry. I'll start early doing some stuff, okay? Now that I can use against your huh? Now I can use against you. LOL FaceTime. See? Are you giving Woody a ride Monday? You go. Yeah, what kind of crazy questions that? No, I'm not giving Woody a ride. Sylvia, you work hard for us. We love you. Good night, Kimberly. Thank you, Kimberly. At least you understand. Do you think Kayla wasn't believed because they knew she wasn't honest about officer who told her? Or she wasn't honest about officer who told her? Huh? About she said she wasn't honest? Oh, this is a question. No, I'm not gonna ask you a question because then y'all keep me on here all night. I gotta go. Good night. Please go live tomorrow I need to watch. Okay, we're gonna go live tomorrow, Molly. Tomorrow we're gonna go live in the morning because I can just. If y'all don't complain, I'll play my little camera footage because y'all come in here and start complaining about the audio. Oh, the sound is terrible. Sound is off. Oh my God, why are we playing this? I can share pictures. I can share my camera and stuff. Okay, if y'all don't complain, because y'all like to complain about everything. Y'all complain if it's this, complain if it's that. Yeah, a lot of people in here are not sounding like any God-fearing people to me, advocating for serious dishonesty. You know, Robert, now all of a sudden you're the priest. Now you're the priest of the chat. Robert's trying to be the priest of the chat. Robert, come on now. You know people gonna be people. Write your question down for tomorrow. Go to sleep. Yeah, I'm going to sleep. Come on, 5 minutes. Come on, Sade. Oh my God, Lord, Sade. 5 minutes. See how selfish you guys are, Sylvia? I've been holding this very long time. I can't hold it any longer. Hold on. Okay. Hold on. Oh, now you're gonna make me cry. Infamous Sylvia, I've been holding this a very long time and I could not hold it any longer. So here it goes. You look like my mom. When I see you, I just smile and some days shed a tears. Oh, some days shed a tear. I lost her in 2008. Oh, that is so. That's a compliment to me. If I remind you of your mom. You like your mom, right? I just want to make sure you like your mom, right? Do you like your mom? Then if you like your mom, then I'm good with it. If you don't like your mom, I don't want to be your mom. That is sweet. Sade, can I go to bed now? Sade, can I go to bed? I was just messing with you. We've talked to. Okay, guys, I'm gonna go to bed. Good night. I have a slight headache right here now. That's because I need to go to sleep. That's that headache sleep headache. See, I see I'm getting all tongue tied and good night, Amy. Good night, everybody. I'm going to bed. Good night. Let's play the church song. Let's say our prayer. May the Lord watch between me and thee while we're absent one from another. Amen. All right, let's play our church song as we disappear from here. Good night. May God bless you. May the Lord God bless you real good. Let me stop. Okay, but good night.